What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. So, the trial for Zachary Hughes, the man accused of killing Christina Parcell, goes on trial Monday. And from what I've heard, they don't anticipate jury selection to take very long. Maybe by lunch Monday, we could have a jury. There will be some motions that need to be argued. And then I heard we could have openings as soon as Tuesday morning. I'll be in court every single day. I'll be live streaming the trial on my YouTube channel, so come watch. Also, at the end of every day, I'll put out a recap. I've completed the backstory on the case. I really just wanted to get that framework for you guys so that when trial starts and these daily updates begin, you know what we're talking about. Zachary's trial was supposed to have started on October 28th of last year, but there was a big fight for discovery going on. The defense filed a motion on September 11th saying that they had requested access to Post's electronics 5 times over the 3 years since the arrest up until that point. That's the reason this trial did not start last year. But the prosecutors want to keep any evidence of the child sex abuse material out of this trial for a lot of obvious reasons. In the prosecutor's filing, they go through the history. And just a trigger warning, I am not getting graphic on this episode of some of the things we know about what was found on Post devices. But I am going to read this little part at the bottom because it's very relevant. It says, included among the images discovered on Post devices are the images of both Parcell, and they have initials, and we know that is a minor. Several images of Parcell and the minor are sexually explicit. The prosecutors say that the body was discovered by Post, and when law enforcement arrived, he was in a sports coat and khakis. The Ring camera from across the street doesn't show his car at the residence at the time of the murder, and the search of his home didn't turn up any clothes like the ones the suspect was seen in. And after running diagnostics on Post's phone and electronic devices, they found no searches, communications, or even a mention of Zachary Hughes. So they're just showing all the ways he's not a suspect in Christina's murder and really hasn't been since day one. If you remember back on that first backstory episode, we talked about how at the time of the murder, he was seen somewhere on camera and clearly wasn't there. They lay out the basic facts that we already know, and then they get into their argument. The prosecution says any evidence relating to Parcell, Post, or her minor child regarding allegations of participating in, possessing, or distributing child sex abuse material is not relevant to the determination of whether the defendant committed the murder of Parcell on October 13th, 2021. More specifically, the evidence has no tendency to make the existence of a fact that is of consequence to this murder more or less likely, nor is there any evidence to show that this potential involvement in child sex abuse material would assist the trier of fact in determining the question of who committed this murder. They cite from State versus Schmidt and say another way of determining relevance is if the evidence would assist a jury at arriving at the truth of an issue. As a general rule, all relevant evidence is admissible. The defendant is charged with murder, possession of a weapon during the commission of a violent crime, conspiracy, harassment, and burglary in the first degree. For all charges, Parcell is the sole victim. The state anticipates at the trial the defendant will attempt to introduce testimony from Post and law enforcement regarding Post's pending child sex abuse material charges and the discovery of that during the course of this investigation. In essence, the defense will try to assert that because Post was in possession of and associated with the materials, he is more likely to have committed the murder. By this logic, the defendant would be using the shock value and heinousness associated with the subject of abuse materials to project what is ultimately a connection between Post and the murder of Parcell. Post devices, which contained the materials to include his phone, contain no communications or material pertinent to the murder investigation, nor any material that the state would present at trial. where the defendant may attempt to offer the evidence as being construed towards some sort of motive or lack thereof, it would require the defendant to present facts which create some nexus between the murder and the abuse materials. To that end, the defendant would either have to testify or call a witness to establish the relevance of such testimony, as no evidence collected, including all electronic evidence gathered by the state, provides that any witness had knowledge of the abuse materials outside of post. The evidence is not applicable towards third-party guilt. The evidence lacks cohesion with the facts and only serves to cast an emotional and inflammatory suspicion at a state witness to the jury. They cite the Supreme Court saying that before such testimony can be received, there must be such proof of connection with it, such as a train of facts or circumstances, and tends clearly to point out such other person as the guilty party. They go on to say that the state anticipates in opening statements or in the course of post testimony, the defendant will attempt to introduce statements, testimony, or physical evidence as related to the abuse material, and post, at the point the mere mention of child abuse materials is introduced, there will be no unringing the bell, regardless of any instruction by the trial judge. And at this early stage in the trial, for the defendant to establish such proof of connection of the abuse materials with the murder itself, or the underlying harassment and conspiracy for that matter, to clearly point post as the guilty party. They cite some case law and say that the goal of allowing this in would be to raise a hypothesis that the murder was committed by post through unrelated, pending, and heinous charges that he has pending, and the court must take preventative action to exclude such evidence. In another section titled The Evidence, they say it's improper impeachment evidence of post. Witness may be impeached about specific prior acts, but only if they relate to the character of truthfulness or untruthfulness. Post faces charges that are being prosecuted by the South Carolina Attorney General, and he's been offered no deal in exchange for his testimony, where post testimony is limited to the context of his discovering Parcells' body. The legitimate tendency to throw light on his truthfulness in questioning him as to his pending child abuse material charges is de minimis. That is a legal doctrine, by the way, that allows courts to disregard matters that are considered trivial or unimportant. It opens the door to many issues and considerations that are collateral and not in any way relevant to the jury's considerations. And they go on to say that his pending charges should not be subject to impeachment by the defendant. Should the court find the abuse material is relevant to the charges facing the defendant, this court should exclude such evidence as its probative value is substantially outweighed by its prejudicial effect in confusing the issue of the case and misleading the jury. Unfair prejudice may arise from evidence that arouses the jury's hostility or sympathy for one side, confuses or misleads the trier of fact, or unduly distracts the jury from the main issues. What does the defense say? They filed their response on December 19th of last year, and they say there are countless scenarios at trial, both foreseeable and unforeseeable, that would render this evidence admissible. They list all the charges Post is facing and say, despite Post and Parcells' prolonged, calculated, and disgusting conspiracy to victimize and abuse young children, the state has indicated as recently as December 4th, Post is a material fact witness and is a potential prosecution witness. On at least 5 separate occasions over 3 years, both in writing and orally, defense counsel requested access to the contents of 8 devices owned by Post and seized by the Greenville County Sheriff's Office in October of 2021, which contained the child abuse material. The state refused defense counsel access to any of the contents of the remaining devices until September 2024, and the state filed its initial motion in limine on September 12th, which sought to exclude the abuse material before it even provided defense counsel access to this material. They wanted to exclude this evidence so much that it didn't want Mr. Hughes to be able to respond to the motion. How could he respond when he had not even seen the evidence that was the subject of the motion? Since the filing, the state has begrudgingly granted defense counsel access to the child abuse materials. Defense counsel has met with personnel from the Greenville County Sheriff's Office to review the contents of these devices. The review has caused defense counsel to conclude that the contents of the devices are even more material to the preparation of Mr. Hughes' defense than they initially believed. Christina Parcell and Brad Post worked together to victimize young children, whether the state likes it or not. In the more than 3 years that has prosecuted this case, the state's attempt to purge the case of this fact has caused it to pursue courses of action that are inconsistent and contrary to state and federal law. In addition to initially providing contents of one of Post's devices in discovery and then denying access to the rest, and in addition to filing a motion in limine publicly and then filing an amended motion in limine on the same issue under seal, the state now invites this court to speculate on what may or may not happen at trial, at least 3 weeks away, and rule that all of the child sex abuse evidence is inadmissible. This court must reject the invitation. Soon, Mr. Hughes will address the misplaced arguments the state makes in support of its motions, but first, he wishes to correct misstatements the state has made both in its written motions and orally before the court. The next section is defense counsel's standby comments they made in Mr. Hughes' motion for bond. In a companion motion to its motions in limine, the state motion for gag order, the state references language contained in Mr. Hughes' motion for bond, which was filed on October 30th, 2024, and accuses the defense counsel of making irresponsible and baseless allegations. And they quote from that, defense counsel brazenly alleges that the victim of this murder, Parcell, produced, directed, and participated in child abuse materials. Not only is the allegation inadmissible, it cannot be proven by the defendant and is wholly unsubstantiated. Further, the state's motion claims that should defense counsel continue to litigate discovery issues related to the abuse materials, they would be releasing unfounded, salacious, and ultimately criminal accusations towards the victim. Also, in its motion for a gag order, the state refers to language in Mr. Hughes' motion for bond that Parcell produced, directed, and participated in abuse material as allegations, wholly unsubstantiated, unfounded accusations, and unfounded allegations no less than 7 times. In its amended motion in limine, which the state improperly filed under seal on November 6, 2024, it continues to claim that defense counsel would be irresponsible if they were to allege publicly that Parcell and Post committed a crime. They quote, defense counsel would be releasing unfounded, salacious, and ultimately criminal accusations toward Parcell. At Mr. Hughes' bond hearing, the state doubled down on its unfounded allegations rhetoric, and they quote the state has serious concerns about defense counsel saying things that are not true or alleged or unsubstantiated about Parcell in public filings, end quote. On December 25th, 2024, defense counsel met with members of the Greenville County Sheriff's Office for the purpose of reviewing the contents of Post devices to which the state had denied Mr. Hughes access for more than 3 years. During the review, defense counsel viewed the contents of a thumb drive law enforcement seized from Post. They go on to describe what they saw in this video with Christina Parcell and a minor child. I'm not going to read it here, but it is as bad as you could imagine. They go on to say that Christina produced, directed, and participated in child abuse materials. They found many other files with similar images and realized defense counsel claims that were well grounded and supported in fact and simply the truth. The state's attempt to exclude an enormous universe of evidence, more than 15,000 images and videos of child abuse material contained on 9 electronic storage devices. They asked the court to defer ruling until trial to allow for the resolution for questions of foundation, relevancy, and potential prejudice in proper context. And they say the state's failure to describe what it seeks to exclude also reinforces the conclusion it may not have reviewed the contents of post devices. So we'll see where it goes with that. I'll be in there every day. I'll also be doing some live tweeting. If you want a more in-depth dive into this case, Fitz News did a great job with 6 episodes on their YouTube channel, deep dive in this case way further than I went. I highly recommend you check it out. They're very well done, and it sheds a lot of light on things that I just didn't get into. That is it. We will see you guys on Monday. I'll recap what happens in the courtroom. Until then, hope you guys have a great weekend. We will see you soon.